Okay. So we are done with judiciary. So if I ask you if the Supreme Court has the powers to transfer a case from the High Court to itself, would it be correct? Can you go to the Supreme Court from any lower court in the country? Is it correct? From any lower court, can you come to the Supreme Court under a provision? Yes, special leave petition. And if the case has to be transferred from one High Court to the other, can the Supreme Court do that? Yes. Simple, clear, effective. Okay? All right. Now we move to the next set. Though extremely important for the mains, but very limited in proportion for the prelims exam, federalism and local self-government. It has to be done with extreme caution, with very, very limited amounts that have to be prepared for the prelims exam. You will not breach the circumference of this lecture as far as these topics are concerned, and others also, as a matter of fact. So we will first start with federalism and center-state relations, and then we will move to the principles of local self-government and apply them, right? Now, the first set of questions that the UPSC more often than not asks is the interlinkages of federalism with other principles and concept of law. The first and the most important feature of federalism is that it establishes what is called dual polity, a layer of government at the center and a layer of government at the level of the states. 2. For effective federalism to exist and flourish, constitutional supremacy becomes paramount. If the constitution is not a higher law than all other laws, you will not be able to safeguard and ensure that the states are felt a certain way and are given a certain amount of sort of position. Are we clear on this? 3. A written constitution is essential for effective federalism. Unless you have a single document clearly outlining the powers of the center and the powers of the state, you cannot effectively be fair and impartial about it. 4th, specifically with respect to changes in the power structure between the center and the state, the constitution has to be rigid about it. The way you could change other provisions of the constitution versus the way with which you could change federal provisions must be given a higher degree of rigidity, right? And if there are two players in the power game, there are bound to be conflicts, which is why you would require an independent, authoritative judiciary for the same. So any of these 5 words, along with federalism, become essential and will be right answers in our options. Dual polity, constitutional supremacy, a written constitution, yes, a rigid constitution relatively, and independent judiciary. These 5 are essential features of effective federalism. Clear? 5. Dual polity, constitutional supremacy, written constitution, relative constitutional rigidity, and independent judiciary. You have these 5, you are absolutely sorted. These are 5 absolute essentials. Clear? Once we've understood the principles of this, we then get into the relations. There are essentially 3 kinds of relations categorized by the Constitution: legislative and administrative, and financial. Now, in terms of a constitutional arrangement, legislative and administrative relations are collectively mentioned in Part 11 of the Constitution. And because financial relations have a certain depth and a certain stature, The makers of the constitution have dedicated a separate part in the constitution to financial relations. So part 11 contains legislative and administrative relations, and part 12 contains financial relations. So what relations are we talking about? Who is the center having an interaction with? You're having interactions with states, with union territories, with legislatures, and union territories without legislatures, right? These are the three different kinds of federal units that exist: states, union territories with legislatures, and union territories without legislatures. Now, within these special federal units, within states, within union territories without legislatures, there are some geographical areas, there are some states where some additional protections have to be given. For that, you have Schedule 5 and Schedule 6 and Article 371. So center into states, union territories without legislatures, union territories with legislatures. Within this framework, Schedule 5 areas, Schedule 6 areas, and 371 applications. Clear? This is the federal framework. It will exist in this ecosystem. And this ecosystem will thrive on three simple principles. The first is, the center will be stronger than the states, rule number 2. Second, all states are not going to be equal amongst themselves. They don't have equal representation in the Rajya Sabha. Some states may get some special provisions under 371 and so on and so forth. And all states are not equal before the center. Hence the concept of symmetrical and asymmetrical federalism. Three simple principles. Center stronger than the states. All states are not equal with each other. And all states are not equal before the center. So this becomes the framework on which your federalism functions. Are we clear with this so far? We've got 5 characteristics, we've got 3 layers, and we've got 3 principles. Okay? Good. Now, we take a microscope and we now get into center-state relations. What is extremely important for the prelims are legislative relations, then administrative, and then financial. Clear on this? Understood? Good. So legislative relations are governed in 2 forms. There are 2 forms of legislative relations: ordinary relations and extraordinary relations. Ordinary legislative relations are as per the prescriptions of the Constitution. Who has the powers to make laws on what? Extraordinary legislative relations are those where the center is going to play a higher role, where the parliament is going to play a higher role. That is the fundamental difference. Okay? Clear on this? Good. Now, what are your ordinary legislative relations? Schedule number 7. Union list on something on which the parliament can make a law. State list on something on which the respective state legislatures can make a law. Concurrent list on something on which both can make a law. And unless there is a conflict with the central law, the state law can exist. And if at all there is a conflict, the legal term for this is repugnancy. The central law will prevail over the state law. Ye clear hai? And if there is something which is not mentioned in either of the lists, the union list, the state list, or the concurrent list, in that scenario, you will notice that the parliament will have the powers to make those laws. So the residuary powers are also given to the parliament, and it is nothing but an application of rule number 2, the center stronger than the least. Any law made by the center or the states under Schedule 7 or otherwise is subject to basic structure. An ordinary law made by the parliament or the legislature under Schedule 7 or even residuary is subject to basic structure. Are we clear on this? Do we understand this? Yes. This is done by an express judgment of the Supreme Court, the Madras UR Association case, the Madras Association case, but the judgment is not important. Are we clear? Anything beyond this is irrelevant as far as the pre is concerned. Now we come to extraordinary legislative relations. The principle behind extraordinary legislative relations is the parliament can make a law on something which could be done by the states. That is the principle. And there are essentially 5 extraordinary such possibilities. The first of it is in national interest. In national interest, the Rajya Sabha can authorize the parliament on making a law which is originally in the state list or a state law. And this authorization by the Rajya Sabha, as we have discussed before, will require a resolution to be passed. It will be a resolution that will have a statutory effect. Remember 2 kinds of resolutions? And this resolution, which will have a statutory effect, yes, will require special majority 1. More than 2/3 of present and voting, that is it. Correct? Yes, that's it. The second extraordinary way in which the parliament can make a law over something which could be done by the states is in the case of a national emergency. The third is in the case of a state emergency. And here what happens is, it is a collective effort by the president and the parliament. We will do the emergencies in a fair amount of detail. So first is the national interest, second is the national emergency, third is in state emergency, fourth, when the states are requesting you to do this. When the states are requesting you to do this. Clear? So when is a request from the states, which means a resolution has to be passed by the state legislative assembly, requesting the parliament to make a law on something which originally the states could. 2 or more states can also request, 3 or more states can also request, no problem. That resolution should be passed by what majority? Special 1 or 2? The resolution which is required by the states to authorize or to request for a council is 2. For a council is 2. But if the state assemblies are passing a resolution requesting the parliament to make a law on something which is in the state list, is it 1 or 2? 1. 1 or 2? ऐसे क्या बोली लग रही है क्या? Simple majority. Very good. Or if a resolution to that nature is being passed by the assemblies authorizing the parliament to make a law on something which is for the states, they're willingly transferring it. Therefore, it is silent on what majority is needed. Correct? And then, if the parliament has to make a law to implement an international treaty or agreement, there no majority needed, no request needed, nothing needed. The parliament can directly go, no terms and conditions. So the only way in which the parliament can make a law over something which the states can get affected by, and you don't need to ask the states at all, is to implement an international treaty or an agreement. Why is that the case? Because it is within the domain of the parliament to accept international treaties and agreements. It's a function of the union list. Clear? Okay? That is it. इसके ऊपर प्री में लेजिस्लेटिव रिलेशंस में एक लाइन नहीं आएगी. बस. The administration will have the powers which the legislation gives the administration to. The administration will have the powers that the law gives the administration the powers to, which is why administrative powers are usually a subset of legislative powers. Okay? And there are only three reasons, where the center can supersede the states for administrative purposes. First, if you're implementing a central law, फिर तो करना पड़ेगा. Second, provisions with respect to all India services. And third, आप अगर essential infrastructure build कर रहे हैं, रेलवे, कम्युनिकेशन, मिलिट्री, अगर मिलिट्री बोला कैंटोनमेंट चाहिए तो कैंटोनमेंट चाहिए बॉस. आप नहीं बोल सकते कि मेरा फेडरलिज्म जा रहा है, अब देश ही नहीं बचेगा तो फेडरलिज्म का क्या करोगे. क्लियर? सो देयर आर थ्री एडमिनिस्ट्रेटिव सुपरसीडिंग्स. There are three administrative transgressions broadly. One, anything that needs to be done to implement a central law, anything in relation to all India services, and anything to establish essential infrastructure, military, communication, and let us say railways. Okay? Bas. Financial relations between the center and the states don't have to be done. वो जो unnecessary articles है कि टूथपेस्ट बोलोगे तो सेल्स टैक्स कौन किसके पास जाएगा. The only thing we need to know is we've had the 101st constitutional amendment which has brought in the goods and services tax. We have three forms of GST: CGST, SGST, IGST. बस. If the GST is registered in Delhi and the services are taken in Delhi and the payments are being made from somebody headquartered in Delhi, so SGST, CGST. But if the company is headquartered in Bangalore, I am working in Delhi, so they will issue what is called IGST. बस कुछ नहीं कर. यहां अपने आप को रोक देना है कि नहीं सर प्री में आ गया तो, जब 10 साल में नहीं आया तो अब भी नहीं. यू आर नॉट स्पेशल. हम सबको लगता है कि हमारे साथ ही होगा. ठीक है? और आप बेसिक प्रिंसिपल्स पे खेल जाओगे. आप बेसिक प्रिंसिपल्स पे आंसर निकाल लोगे. वैसे भी आपसे वो फैक्चुअली पूछ नहीं सकते, वो आपसे टेक्निकल ईयर पूछते नहीं है, तो करके क्या करो. 10 साल पहले होता था कि सेल ऑफ टूथपेस्ट तो टैक्स स्टेट के पास जाएगा, सेंटर के पास. अब तो सब जीएसटी. ठीक है? जीएसटी काउंसिल इज इंपॉर्टेंट, जो हम बॉडीज में करेंगे अभी. ठीक है? बस. These are your broad principles of relations. And an extraordinary application of these principles are your emergencies. जितना बताऊंगा उतना ही करना है, ना उससे एक लाइन ऊपर ना उससे एक लाइन नीचे. इमरजेंसी आता है बिकॉज इमरजेंसी एक्स्ट्रॉर्डिनरी. क्लियर? नाउ there are three kinds of emergencies: national, state and financial. In each emergency we are just going to know 5 things. On what grounds can you do it? Where would it apply? What effect does it have on legislature and executive? What effect does it have on fundamental rights? And how long can it be extended for? बस और कुछ नहीं आएगा. क्लियर? जितना आएगा इतने में से बस. So first is national emergency under 352. There are 3 grounds as of today: war, external aggression and armed rebellion. तो अगर आप वॉर बोल दोगे ना, WAAR, तो ग्राउंड्स वहीं से निकलेंगे. वॉर, अग्रेशन का A, आर्म्ड रिबेलियन का AR. So you'll never forget the grounds. Clear? Understood? या फिर WEAR, where, war, external aggression, armed rebellion. These are your grounds for national emergency. WEAR. You will never forget them. These are your grounds. National emergency could be to the entire country, to a state, to 2 states, to a part of a state, all okay. There is no territorial limitations on national emergency. ये clear है? ठीक. बस. Now what is the ground for national emergency? War. There is some security threat, right? इसका लेजिस्लेचर और एग्जीक्यूटिव के होने या ना होने से क्या फर्क पड़ता है? उनकी वजह से थोड़ी ना वॉर हुआ है. So your Lok Sabha, your Rajya Sabha, your assemblies, your councils, they are not suspended, they are not dissolved. Nothing happens. इनकी वजह से थोड़ी वॉर हुआ है. वॉर तो वॉर है. Why will I restrict the mandate during a war? Clear? So nothing happens to the legislatures, nothing happens to the executive. They remain as it is. None of the houses, UCOM, ESCOM, कोई हाथ नहीं लगाता, कुछ नहीं होता. But war है, so sometimes we will have to take the power from the states. कि अगर कुछ एग्रीकल्चर से रिलेटेड हो गया, फूड का ध्यान रखना है, इकोनॉमी मतलब एसेंशियल कमोडिटीज का ध्यान रखना है, लॉ एंड ऑर्डर का ध्यान रखना है ना, हेल्थ का ध्यान रखना है. So the only impact that the national emergency has on legislatures and executive is the parliament can make a law on the state list. बस. जहां जहां नेशनल इमरजेंसी है वहां वहां सिर्फ 2 लिस्ट है, यूनियन लिस्ट एंड कॉन्करेंट लिस्ट. स्टेट लिस्ट है ही नहीं. This doesn't mean that the state assemblies cannot make a law. They can. But the parliament can also. बस. जरूरत पड़ी तो तुम्हारे लिस्ट के तुम्हारे सब्जेक्ट पे हम कानून बनाएंगे, चुपचाप इंप्लीमेंट कर. And the parliament will make the law. Rule number 1, democratic mandate. प्रेसिडेंट कभी भी ऐसे कानून नहीं बना सकता. Clear? So the parliament will make a law. Clear? Understood? Good. बस. लेजिस्लेचर और एग्जीक्यूटिव पे बस इतना ही इंपैक्ट है और कुछ नहीं है. बट इंपैक्ट राइट्स पे है. इम्पैक्ट राइट्स पे। द सेकेंड 352 is promulgated. आर्टिकल 19 तो जाएगी ही जाएगी कि वॉर है, आपको घूमने फिरने, नाचने गाने, एसोसिएशन बनाने, बोलने चालने की आजादी थोड़ी ना देंगे। यस, यहां लगे पड़े हैं। द वन थिंग वी विल टेक अवे इज 19. The one thing we can't take away is 20 and 21. 19 तो जाएगी ही जाएगी, 20 और 21 जाए ना जाए, उस 2021 जा नहीं सकती। बाकी 14, 15, 16, 17, 18, 23, 24 वो आपकी श्रद्धा पे है कि यहां वॉर है, इनको यहां पे वैष्णो देवी जाना है। समझ में आ रहा है कि क्रिसमस मना रहे हैं? क्लियर? 19 is automatically suspended. 20 and 21 has to be suspended. There is no option whatsoever. Sorry, 20 and 21 can't be suspended. 19 has to be suspended. Now comes the tricky part. 32 and 226 can temporarily be suspended. इसका क्या मतलब हुआ कि ड्यूरिंग द टेन्योर ऑफ द इमरजेंसी तब कोर्ट मत आना, बिकॉज 20 and 21 कैनॉट बी सस्पेंडेड, सो द गवर्नमेंट कैनॉट वायलेट 20 and 21. बट व्हाट इफ गवर्नमेंट हैज वायलेट 20 and 21? वेट फॉर द इमरजेंसी टू बी ओवर, कम टू द कोर्ट, वी विल हेल्प। ये क्लियर है? बस हाँ, आप चाहो तो, हाँ, सिर्फ 19 ऑटोमेटिक है, बाकी सब चाहो तो है, नहीं हो सकता। ये क्लियर है? क्यों नहीं हो सकता? लाइफ एंड लिबर्टी बहुत मैग्नानिमस है, एंड 20 इज योर अरेस्ट प्रोटेक्शन, योर क्रिमिनल जस्टिस प्रोटेक्शन, कि इमरजेंसी की आड़ में आप लॉ एंड ऑर्डर की धज्जियां नहीं उड़ा सकते। ठीक है, अरेस्ट हमने कॉम्प्लिकेट कर दिया, प्रिवेंटिव डिटेंशन हमने कॉम्प्लिकेट कर दिया, बट द प्रिंसिपल्स ऑफ क्रिमिनल जस्टिस दे कैन नॉट बी टच्ड। ठीक है, बस जितना मर्जी चलाना है, जैसे चलाना है चलाओ, लेकिन 6 महीने पे। It will run for 6 months at a time because maximum gap between 2 sessions is 6 months. ठीक है? Understood? Good. अब emergency लगती कैसे? The only time in the constitution the word cabinet has been mentioned. The cabinet in writing recommends to the president that emergency has to be promulgated. The president is bound by the advice of the cabinet. The president is bound by the advice of the cabinet. Are we clear on this? Do we understand this? Now, at the end of the day, the parliament will have the powers to make laws on the state list. That means the only person who can authorize the parliament to do so is the parliament. Yes, rule number 2, center stronger than the states. तो राज्यसभा का भी रिफ्लेक्शन आना चाहिए, करेक्ट? तो अगर 1 जनवरी 2023 को नेशनल इमरजेंसी प्रोक्लेम हो गई है, तो महीने भर के अंदर पहले अप्रूव कर, महीने भर के अंदर अप्रूव कर। A national emergency can run as a national emergency without parliamentary approval for 1 month. That approval comes also with a majority of the parliament. ठीक है? और ये नहीं कि एक ही हाउस, दोनों हाउसेस को स्पेशल majority 2 by 2 because फेडरल implication है, more than 2/3 of present and vote. आया समझ में? बट वो 6 महीना 1 जनवरी से काउंट होगा. ठीक है, ऐसे समझो. When I'm looking at a national emergency under Article 352, I know my grounds are very clear. WEAR. It is not impacting the legislature. It is not impacting the executive of both the center and the states. The only difference is the parliament can make a law on something which is in the state list. And this could be applied nationally, states, or a proportion of it. अब क्या करें? ठीक है? Understood? Now, because this is nothing but an aggressive form of center stronger than the states, कहीं ना कहीं हमको स्पेशल majority 2 तो लगेगी. That is why you have only 6 months at a time for n number of times. 1st January को आपने प्रोक्लेम कर दी, लगा दी. Within 1 month, both the houses of the parliament, the Lok Sabha and the Rajya Sabha, will have to approve this. And this has to be done through special majority 2. This is also one of the reasons why Rajya Sabha is a continuous house. उसके बाद it will continue for 6 months starting 1st of January. And every 6 months you can extend it for another 6 months. Exit. Okay? Understood? National emergencies or any emergency is judicially reviewable. Is judicially reviewable. ठीक है? आप कुछ पूछ रहे थे तो बुलाओ ना. Clear? So this is it for national emergency. It's called special session. Then comes state emergency और प्रोक्लेमेशन ऑफ प्रेसिडेंशियल रूल. उनका ग्राउंड बहुत सिंपल है और ग्राउंड से ही आधी कहानी क्लियर हो जाती है. द फेलियर ऑफ कॉन्स्टिट्यूशनल मशीनरी इन अ स्टेट. द फेलियर ऑफ कॉन्स्टिट्यूशनल मशीनरी इन अ स्टेट. सो will a state emergency be applicable to a union territory without legislature? Because a union territory without legislature is under the overall supervision of the center. अपने पे ही थोड़ा ना लगाओगे. Yes? Good. Ground से सब क्लियर है. So if it is about the breakdown of constitutional machinery in a state, it can only be applicable to a state. That is the extent of it. कि बिहार में प्रॉब्लम है, जाके तमिलनाडु में बना रहे हैं. 3. It is the breakdown of constitutional machinery in the state. No fault of the center. Nothing happens to the central legislatures or the central executive. Yes? State legislatures are simply not functional anymore. They may be suspended, they may be dissolved, depending on case to case. They are simply not functional. MLA को बोलते हैं अभी जरा घर बैठो कुछ दिन. अब हम देखते हैं ठीक है, अंडरस्टूड. And the state executive is definitely suspended. Because if the constitutional machinery has broken down, it's because you haven't been able to uphold the institutions which the constitution gave you. And upholding and implementing is a problem of the executive. The constitution is broken down because the executive has failed. So simply, the state executive is suspended. Clear? The president then takes over the administration of the state. ठीक है? But does the president have the powers to make laws on the state? No. The parliament may make laws with respect to the state. तो बेसिक डेमोक्रेटिक मैंडेट है. प्रेसिडेंट कब से कानून बनाने लग गया भाई? ठीक है. So in a state emergency, no impact on central legislature and executive. The state legislatures may be dissolved, may be suspended, but they're certainly not functional. And the state executive can be suspended by the president. Is definitely suspended. So state emergencies necessarily lead to the suspension of the state executive. It may or may not lead to the suspension or the dissolution of the assembly. The parliament may make laws, doesn't necessarily make laws. And the president, through the governor, takes over the administration of the state. तो सीएम की पावर्स थी, वो गवर्नर और प्रेसिडेंट अब एग्जीक्यूट करें. क्लियर? आया समझ में? ब्रेकडाउन ऑफ कॉन्स्टिट्यूशनल मशीनरी का राइट से क्या लेना देना भाई? इनफैक्ट इफ यू टेक अवे राइट्स, you would further break it down. So there is no impact on fundamental rights of any kind in a state emergency because it has nothing to do with rights. You're restricting your rights in national emergency because the country is at war. Why would you restrict the rights in a political crisis? In an execution crisis? It is just counterproductive. Right? Now, a national emergency could run for infinity technically 6 months के intervals. There is a maximum limit on how long the states can run. 3 years. 3 simple years. You have to approve a national emergency within 1 month. You have to approve a state emergency within 2 months. Center stronger than the states. कि 2 महीना पार्लियामेंट अप्रूव करे ना करे, कोर्ट जब तक कुछ बोले चला. That is why presidential rules are often contested. There are often debates around whether this was legitimate or not, whether it was necessary or not. ठीक है? The first time you can implement a presidential rule is 1 year, then 6 months के 4 interval. So 1 + 6 + 6 + 6 + 6 जो भी एग्जाम में नहीं है. The governor can recommend the imposition of presidential rule. It is a constitutional discretion of the governor. The president is not bound by it, and neither has the president supposed to wait for it to impose an emergency. दिया तो तुम्हारे कंधे पे, नहीं दिया तब भी मैं प्रेसिडेंशियल रूल लगा सकता हूं. और दिया तो लगाना है ये कंपलसरी नहीं है, और नहीं दिया तो नहीं लगाना है ये भी कहीं नहीं लिखा है. सो अल्टीमेटली इट बिकम्स अ वेरी वेग प्रोसेस टू बी. क्लियर? अंडरस्टूड? इसके ऊपर स्टेट इमरजेंसी कुछ नहीं, नथिंग एट. Clear? Good. Then comes financial emergency, 360. Grounds भी बहुत वेग है. When the financial security or the financial stability of the country is under threat. बस इतना लिखा है. It is the most undefined emergency, which is why there have been questions from here in the mains exam. कि इससे होता क्या है? नहीं तो फैक्चुअल होता ना बाकी सब. The constitution is unclear whether the financial emergency could be applied to the entirety of the country or a part of it. Can a financial emergency be applied state-wise? Not written anywhere. Can it be applied to northern India and southern India? No. ऐसा कहीं नहीं लिखा है. Clear? No. बता रहा हूं ना. तनख्वाह कम होती है. बस. So if there is a financial emergency, why do I restrict the law making and the law implementation processes? So no impact on any legislature of any kind whatsoever. Ground ही नहीं है. And what has financial emergency to do with fundamental rights? And you don't have the right to equality anymore. कड़की चल रही है. और नहीं लगेगा. और आपको नहीं पता कि आपकी कड़की कब तक है. You will never know how long are we going to be broke for. And let me tell you, no matter where you are in life, the end of the month is a difficult period. No matter who you are. Last week of the month, तुमने देखा स्टार्टिंग में 3-4 दिन क्या बढ़िया मैं कॉफी पी के आ रहा था. अभी चुपचाप यहाँ की चाय पीता हूं. Financial emergency. So what does financial emergency do? It simply says खर्चे कम करो चाहे कोई भी हो. बस. किसी की भी तनख्वाह कम करनी है करो. चार्ज एक्सपेंडिचर हो, मेड फ्रॉम हो, फर्क नहीं पड़ता. यहां बीओपी क्राइसिस चल रही है और अपने सीएजी बोल रहे मेरी तो कम नहीं कर सकते. क्लियर? बस. ना इसके ऊपर एक लाइन आएगी एग्जाम में, ना हमको कर. समझ में आया? बस. It only takes a total of 45 minutes to do center, state and federalism for the prelims. इसके ऊपर कुछ नहीं आता एग्जाम. जुडिशरी तक हाथ पांव मारने पड़ते हैं कि यार ये भी पढ़ लिया, थोड़ा वो भी पढ़ लिया, थोड़ा इधर से भी उधर से. अब इसलिए इतना आज तक कभी देखा है इसके बाहर के कोई क्वेश्चन? क्वेश्चन ही नहीं देखे होंगे पीवाई क्यों. ठीक है, प्लीज. 3 years. नहीं तो जम्मू कश्मीर में तो अलग ही प्रॉब्लम है ना भाई. जम्मू एंड कश्मीर में तो आपने 3 साल के बाद लेजिस्लेटिव असेंबली नहीं है.